Welcome to In Plain Sight, a legal commentary on Alberta collective agreements and how they are adversely impacting union membership. My name is Christopher Neufeld of Neufeld Legal, and in this particular video, we're going to begin discussing the adverse impact of collective agreements for Alberta unionized employees. And we're going to provide it more as a commentary than an actual specific breakdown, because a lot of this stuff is discernible but has not been litigated or actively pursued to the degree that we can come to conclusions. Although we can make reasoned deductions based on legal analysis that is available to us. And how do we undertake that legal analysis? Well, we start off by looking at those collective agreements. And because of the way collective agreements need to be put on the internet, they are readily available through the internet to all who want to review them, whether it is union membership, union leadership, or lawyers like myself who are interested in what is actually being put forward. And it's because of this analysis and other reasons that we've undertaken to look at many collective agreements that have been negotiated between the unions and the ownership or the employers without really the active input of the employees that they represent. Yes, employers are effectively represented by the union and the union's lawyers, but the question becomes, how effectively have they been represented? How effectively have these agreements been scrutinized? Because when we look after one after another, we, at least I, have discerned considerable issues with respect to these agreements. And where do these issues emanate from? Well, we can suppose where they are because we look at them and we compare them to collective agreements from other jurisdictions. And what is the commonality there? Well, a lot of the problem, at least in our opinion, appears to emanate from the fact that these collective agreements are reflective of agreements in other provinces and other countries. And when we talk about other provinces, we're primarily focused on the province of Ontario. And if we talk about other countries, we're talking about primarily the United States. Because that is where so much of the lawyers work, and they do so much more work. So whether it's American-based collective bargaining agreements for American unions, or it's Ontario-based collective bargaining agreements in those unions. Because all too often, these unions, when you look at the hierarchy, their headquarters at the very top level is based in the United States. And at the national level, it's based in Ontario. And as such, there is deference provided, or the lawyers that are undertaking the work are all too often based in those provinces. And they are working on a different system of laws, a different basis of statutory aspects, both at the labor standards level and the employment standards level. And this is reflected in the collective agreements. And instead of trying to modify them, analyze them, and make them very particular to the province within which the individual unionized employee is working, all too often it would appear there is a lack of interest, a lack of focus, a lack of dedication, a lack of observation and legal knowledge that goes into these aspects. And instead what happens is you have collective agreements that are highly reflective of another jurisdiction, whether it's at the extra-national level, being the United States, or the extra-provincial level, that being of Ontario. And what does this focus do? It results in serious issues that provide inconsistencies as between what is the law in Alberta or other provinces and the law of the jurisdiction which the collective agreement is premised on. And this in turn results in considerable underpayments in our estimation. Because if you're paying payroll on the basis of another jurisdiction's laws, whether it's another country's or another province's, you will run into issues where you have cross problems between those jurisdictions. And whereas it's entirely permissible under most employment standards legislation and labor standards legislation for an employer to pay more than what the governing statute says, it is not permissible to pay less than what the statute says. So it's always fine to make mistakes that are favorable to the employee if the employer would ever do so. But as we all know, as soon as the employer identifies an overpayment basis, they will quickly correct it and bring it into line. That's what the job of their lawyers and their accountants is, to make sure they are minimizing their expenses. On the flip side, who is supposed to be out there protecting the interests of the employees? Well, the courts sort of have a role, but the courts can't get involved until they are instructed to. They are brought forward. So, for unionized employees, it falls upon the union and the union's lawyers. And this is where a large problem arises, at least in my professional estimation, because they have to be able to discern what the problem is. And part of the challenge for that is the top level union lawyers are not based in the provinces where the issues are arising, because the top union lawyers are either based in the United States or in the province of Ontario. And when you are in those locations where, in our professional estimation, they have lower employment standards, payroll requirements are far less, the calculation methodology is far less, you're not going to pick up that in other provinces you have different calculation methodologies which can result in alterations in the payment structure, even though those payments can be quite significant. But that is the world that we live in, where simplicity, consistency, repetitiveness are all too common. So in Canada, we have the very unusual situation of having over 14 different and distinct employment standards regimes, which provides for different methodologies of calculation of employee payroll. Nevertheless, when you look, at least in Alberta, with respect to collective agreements, you would think that all the provinces are operating under a singular form of payroll regime, which is some quasi-combination of Ontario and aspects of the United States. But as we all know, Ontario is but a single province, and none of the provinces are part of the United States. Nevertheless, that is almost the structure that we find ourselves in. And so when we thoroughly analyze the different methods of calculation, and we really look at how calculations are supposed to be undertaken, we come to the realization that in the province of Alberta, based on collective agreements, all too often there are significant underpayments arising. And this is particularly accentuated with respect to areas of overtime pay, vacation pay, and general holiday pay, otherwise known as statutory holiday pay. And how do we know this without even looking beyond the collective agreement? Well, we don't even have to look at pay statements. We know this from pay statements, though. But when one looks at the collective agreements, you see all sorts of terminology being used, but not the terminology that is required by the governing statute. Different terms, regular rate, base rate, pay rate, hourly rate, are all reflected in there. And those rates are then used and all too often applied in the calculation of overtime pay. And they're also applied oftentimes for the calculation of vacation pay and general holiday pay, which is an operative structure which is permissible both in the United States and Ontario. But if you keep on reading through these collective agreements, you see the other component parts of the pay arrangement that is provided to unionized employees. And for whatever reason, those aspects are not really included in those calculations. Even though we even see charts and extensive calculation practices as to how people earn additional amounts of money, whether it's employer pension contributions, it's health and wellness payments, it's incentive payments, premiums, even sometimes technical bonuses, long-term incentives, short-term incentives, and the like. Those things can and often do get into collective agreements. And yet, even though they're laid out in the collective agreement, they are not put into the calculation methodology for the various payments that the unionized employees are accorded with, whether it's overtime pay, vacation pay, general holiday pay. And in turn, this ties into other aspects also, including termination pay, as well as severance pay, and even pension plan contributions and RRSP contributions. Because all too often, those calculations too need to include these various payment aspects. No, they are not required in the United States. And many of these payment aspects are not required in the province of Ontario. But what we're talking about here is collective agreements in the province of Alberta pertaining to Alberta unionized employees. And those Alberta unionized employees operate under the statutes of the province of Alberta and not under any other provinces or any other country's statutes and laws. And nevertheless, what we're seeing from a straightforward analysis of the collective agreements that they have been made publicly available is that there are major inconsistencies. And these major inconsistencies exist to the detriment of Alberta unionized employees. And in truth, they may well exist for many other provinces. But for the fact that we have not undertaken an analysis of those other provinces as well. We've taken analysis as to the variances in calculation methodologies, but our focus right now is on Alberta and Alberta unionized employees. So what we're seeing, again, in plain sight, is that these collective agreements are not designed, not written, not negotiated in a manner that is consistent with the laws and statutes of the province of Alberta. And why is that? Because they emanate from outside the province. And for whatever reason, they are simply allowed to be imposed upon the unionized employees. And the unionized employees are thought of to not challenge them, when it should be the union reps and the union's lawyers who should be picking up on this stuff. And we question, why is it that they're not picking up on it? I can understand somewhat the union reps because they are not lawyers, they are not accountants. But why is it that the lawyers aren't picking up on it? That is an interesting question that really should be asked of them. It should be probed, because we're not talking about pennies and that is being lost. we're talking about significant amounts of money that pay period after pay period, year after year, is not being paid out to unionized employees. And they are legally entitled to it by the statutes of the province of Alberta. And that's a very important thing to consider. Who is the union there to protect? The union is there to protect the employees. They're not there to make the union reps happy to be in the representative role. They're not there to simply give a paycheck to lawyers and accountants who are negotiating certain things on behalf of the union. And they're not meant to keep the reps and the union lawyers and union accountants in the good graces of the employer, the company. That's not their role. But all too often it seems to be their role, or it's the role they've undertaken. They don't want to rock the cart. They just want to keep things going smoothly and slowly effect increases with respect to certain areas of pay. The problem is, when you look at these minuscule increases that they do negotiate, it's compared to what the amount of money that is, in at least our professional opinion, being lost by the same unionized employees because they're not pursuing what is actively visible, actively discernible from the collective agreement. And that is significant underpayments. And we see these significant underpayments most particularly with people who are working out in the field, people who are working the more difficult jobs, who put in significant amounts of overtime and the like. And for whatever reason, this continues. It self-perpetuates itself because nobody is looking into it sufficiently and nobody is challenging it. And this is something that the union reps should be looking at, something that the union employees should be looking at. And the union employees should be bringing it to the attention of their representatives. Because when you really think about it, whose money is it? It's the union employees' money. It's their personal money that they're not receiving. It's money that they have legally earned, statutorily earned. They've worked for it and they have a legal right to receive it. But for whatever reason, nobody is challenging it. Even though you can discern the mathematical problems from the collective agreements. And is this not what the union should be doing? They should be fighting to get the full amount of earned money paid out to their membership. That is, at least in my personal opinion, what the union should be doing. And unfortunately, is what the union is not doing and is reflected in the collective agreements. So they really have to start looking at this, really have to start pressing them. They have to talk to people who understand what is happening. Because the mathematics, it might seem complicated, but it's clearly discernible. And the math is there in the statute. It tells you the minimum means of calculation. And once you see what the calculations are, and you understand what the formula is and what the numbers are, you see different numbers being created. And that whole formula, that comes from the statute, and that is supported by the law from the courts. And then once we have those formulas, and we start inputting the different variables into the formula, and those numbers, I'm not making them out of some fantasy land or anything like that. I'm pulling those numbers directly out of the collective agreement. So once I take the numbers out of the collective agreement, put them into the correct formulas, not the Ontario formulas, not the United States formulas, but the Alberta formulas. I plug in all those numbers which in Ontario and the United States are not required to be inputted, but in Alberta are. Once I do that, I come with new results. Significantly more money that has to be paid to the employees on each pay period, in each year, with the means to actually go back and collect that money because it has been earned and the statute provides protections to protect that earned money. And it's all in plain sight, yet it has to be pursued. So we hope you return to this YouTube video series that we're looking to start up and start talking about more of stuff that's in plain sight with respect to collective agreements in Alberta and how it's impacting unionized employees and how unionized employees need to be looking into this stuff. Because mine is but a perspective. It is not the legal challenge itself. But if you're not willing to look at perspective, you're not willing to look at commentary, you're not going to get anywhere. But once you start understanding what's being talked about, and you start looking at more and more materials, even your own personal materials, I think what you'll be is shocked. You'll be stunned. You'll be surprised as to what is actually transpiring. And it's all there in plain sight. It's not something that's hidden. The collective agreement is in plain sight for the public. Your pay statements, your employment agreements, they're in plain sight for yourself. For the union rep, all the agreements, all the pay statements, all the negotiations, those too are in plain sight. But simply being in plain sight is not enough. We can talk about it as I am today, but you have to take the next step. You have to analyze it. You have to investigate. And where your analysis leads to the fact that there's underpayments, that is when action has to be undertaken. But we're not there in this video series. What we're talking about now is simply looking at what's in plain sight, doing the due diligence and analysis to bring you one step further and seeing where things go from there. Thank you.